Come to paragraph 31, my lord. WBSSC has also tried to justify the extension of the term of penalty. As noted above, the time period of 1 year specified in Rule 21 for the destruction of the Weimar sheets coincides with the time period specified for the validity of the penalty. There is no doubt that the counseling process and appointment made to the post of assistant teacher for classes 9 and 11 12 were made after the expiry of penalty. This is illegal and contrary to the rules. Reliance on the orders and judgments of the High Court in stray cases of rank jumping, where the High Court directed to appoint candidates after expiry of the validity of panel, would not have any significant impact. The court at that stage was not concerned and aware of the illegalities in the appointment procedure and had not specifically examined the question of appointment after expiry of the panel. Now, my lord, here I stop for a moment. Look, whatever your lordship tried to justify, whatever has been stated in the opposition of the private respondent, state and commission, everything was submitted before the Honorable Supreme Court. Everything. Considering everything, my lord, the court has observed that no appointments given after expiry of panel is illegal. My lord, now there has been another division being judgment of our High Court, my lord. This order is also, my lord, probably met 1016 of 2025 is also, my lord. Your lordship. July 10.
Yes.
My lord, your lordship, this is an appeal, my lord, which has been filed, which was filed by the state and the commission against the order of the coordinate bench, where the coordinate bench held that no tainted candidates should be allowed to participate. From that, my lord, commission and the state preferred an appeal. My lord, if your lordship kindly comes to page 23, paragraph 32.
Yes.
Lord, paragraph 363, Roman 4 has classified three categories of candidates who can be described as tainted candidates. Persons who have been tainted outside the panel, persons tainted after expiry of the panel, persons who have submitted blank waiver sheets to obtain appointments. My lord, first the division bench categorized this. Thereafter, ultimately, my lord, if your lordship kindly comes to paragraph 20, last page 28.
Yes.
Paragraph 40. In view thereof, we are not allowing any appointments, any application.
George Pine.
Page 28.
Yes.
Paragraph 40. In view thereof, we are not allowing any application to be filled by tainted candidates for the recruitment process initiated pursuant to the order of the Honorable Supreme Court. Now, my lord, this paragraph 40 has to be read with paragraph 32. In paragraph 32, it is the division bench categorized who are the tainted candidates. Thereafter, paragraph 40 tells that no such tainted candidates would be allowed to participate in the recruitment process. My lord, this order has not, no SLP has been filed from this order, my lord. Now, even after these specific orders, my lord, I could have understood when a state or commission has filed a review or an SLP saying that no, we want to allow after expiry candidates to participate. Nothing of that sort. They have straightaway allowed candidates who have been appointed after expiry of panel to participate in the recruitment process, and they have been, my lord, included in the panel. And my lord, a figure is not, my lord, figure is at least, my lord, is after second phase. In 19 and 11, 12, the figure will be around 9 to 10,000. So if these 9 to 10
figure of these candidates were appointed after expiry.
And if this candidate goes, my lord, he's pressure. Because of these candidates have not even been considered. Now, my lord, I would like to come, my lord, in short. My lord, in short, my lord, our case is after the division bench judgment affirmed by the Supreme Court and subsequent division bench judgment, it is clear that no person who has been appointed after expiry of panel can be appointed. Now, my lord, if your lordship kindly come.
So all the private respondents over here will be the candidates appointed after expiry of the panel.
Yes.
More or less, we can take it.
Yes, everybody.
Everybody.
And this has been admitted, my lord. I have seen their opposition. They have also admitted that they have been appointed after second phase, but it is not. In some of the opposition, my lord, strangely, has been argued that the appointment is illegal, but not tainted. My lord, your lordship kindly come to page 80 of my dictum.
না পুরনো রুলস এটা নেই অ্যানেক্স নেই
My lord, your lordship kindly not there. Kindly see the 2016 rules first.
It is here, 80.
No,
Page 8.
16 rules, my lord. This is 2025 rules.
All right, you want 16 rules.
My lord, now your lordship kindly comes to rule 16, 15, rule 15.
Rule 15 of 2016.
2016 rules.
Yes.
My lord, validity of panel and waiting. Each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement, that is the next selection process, whichever is earlier. Now, my lord, the panel and waiting list was published after 1 year. Since there was no new selection process, it has expired from the date of publication, my lord, and I have annexed in my reply the date and the repetition when the date of publication of the panel and waiting list, not the date of counseling or appointment. And my lord, next, provided that it is very important, my lord, notwithstanding next to notwithstanding anything contained in sub-rule 1, a panel waiting list, merit list prepared by each of the regional commission before coming into force of this rule also. So, my lord, what is important here in this rule? This rule stipulates, my lord, two things. First, the date of validity of the panel, and more importantly, the commission, my lord, under this rule has no power even to make the panel extended. My lord, whatever they have taken a point, my lord, commission, that there was a court case pending, there was a phase, so we could not appoint them in time. My lord, even in that scenario, the commission has to approach the court or the school education department seeking for extension of the validity of the panel. Because, my lord, the 2016 rule does not provide any power to the commission for extension of the validity of the panel.
Yes.
Now, my lord, I would like to come to the opposition, my lord, filed by the commission first. My lord, I will not refer to the opposition of the private respondents, whatever, my lord.
একটা জিনিস রেকর্ড করে নিই যে আমি প্রাইভেট রেসপন্ড এটা করছি মানে কোনো কিছু অ্যাডমিট করছি এটা সেটা একবার রেখে কমিশনের